Good afternoon. Judge Montgomery has joined us again, so he'll be our third judge. He's the regular judge on this panel. All right, ready to call the final case?
State of Tennessee versus William Tony Burrell.
Thank you, Your Honor.
Counsel.
First, I'd like to introduce myself. I'm Attorney Austin Hayes from the McMinn County Bar. This is my boss, Mr. Matthew Rogers. He's appeared before this court numerous times. This is one of my first times.
Good to have you, Mr.
Thank you. Thank you, sir. I would like to, again, express our condolences for Mr. Witt's passing. He was a personal inspiration of mine. He is from Monroe County, where our second office is from. He went to Tennessee Wesleyan, where I went. And so throughout my whole legal career, he actually did my first trial that was in this courtroom for a mock trial from LMU. So he showed that you can really do anything from a small town. So we appreciate that. On to the case, Your Honor. I'm going to break my time down into two categories. The first is to address the state's response in saying that we did not properly certify the question. Judge, in response to that, I've read over their brief. They have several citations, including State v. Potts and other more recent cases from the Court of Appeals. Judge, I know you guys are familiar with Rule 37 and these certification requirements for a certified question of law. We believe that we have done and followed that procedure correctly. I understand for that procedure to be done correctly, the only thing that the state has pointed out that, in their opinion, we have not done would be to properly identify the scope and limits. Judge, if you read our question, the question is whether or not an unreasonable seizure occurred when the arresting officer blocked the defendant's vehicle into a parking spot based solely on uncorroborated anonymous caller who allegedly reported reckless driving regarding an unknown vehicle and driver. Judge, the scope is whether or not the seizure was reasonable or not. It's not even whether a seizure occurred. We're not here for that. The trial court found that a seizure had occurred, but that it was reasonable. We are only asking this court to determine whether or not it was unreasonable based on the facts that were put in the limits of that certified question. The facts speak to the limits. There was no independent corroboration. Judge, I would like to point your guys' attention to several cases, some of which the state included in their briefs. The first would be State v. Harris in 1995. Your Honor, that's one of the prime examples that I have found where it says the certified question was the validity of the search of the defendant's property where the marijuana was found. That's all that case says. The Court of Appeals said that one was good enough. State v. Cox, which is the Tennessee Supreme Court, stated that, I apologize, Judge, I've turned the page to the wrong one. The question is, as certified in Cox, was whether the consent given to search the defendant's motel room is consistent with the requirements of the United States Constitution and the Constitution of the state of Tennessee. Again, it's a very simple certified question that the Tennessee Supreme Court said was produced properly. Judge, in State v. Day, which was cited by the state in this case, the certified question there was the stop of the defendant's vehicle and seizure of the defendant's person, by which law enforcement obtained evidence that the defendant motion to be suppressed was not based upon reasonable suspicion, supported by specific and articulable facts that a criminal offense had been or was about to be committed. Judge, there are numerous. State v. Nicholson has a simple one. State v. Springer, which is a Tennessee Supreme Court case, doesn't, in its certified question, doesn't say why the trial court denied it. Judge, the state also says that we did not properly put forth the reasons that the trial court denied the case or what we were asking to be suppressed. Judge, there's a plethora of examples where the Tennessee Supreme Court has upheld certified question appeals where these newfound issues like that were addressed in State v. Potts. State v. Potts is a 2018 unreported case, Judge, that the state is relying on, where the Court of Appeals said the reasons relied on by the defendant in the trial court at the suppression hearing and the trial court's reasoning for denying the motion to suppress should be discernible from the certified question of law. Well, Judge, it sets up an ambiguity. State v. Preston, which is the controlling case, which is cited to in the footnotes of Rule 37. It says all lawyers should read State v. Preston. State v. Preston is controlling. All subsequent cases from State v. Preston are cited back to that regarding the certified question of law appeal process. State v. Preston simply says, and I'm just reading to you, Judge. State v. Preston says, where questions of law involve the validity of searches and the admissibility of statements and confessions, etc., the reasons relied upon by the defendant in the trial court at the suppression hearing must be identified in the statement of the certified question of law and limited to those passed upon by the trial court judge to the certified question. Judge Preston makes it very simple. It just says, set out your limits, set out your scope. I believe we've done that. Again, I'd just like to repeat, the scope is, was this seizure reasonable or not? The limits are, can an officer pull someone over based solely on an uncorroborated anonymous 911 tip for speeding? And Judge, with that, I'd like to move on to the merits of the case.
Well, let me ask you one more thing. Inherent in that, in laying out the question, I mean, there has to be some basic authority, whether case law, but is it Fourth Amendment? Is it Tennessee Constitution, Article 1, Section 7? I mean, some basic parameters that we have to work with.
And Judge, with that, two responses. First response would be, I believe we have identified that with the unreasonable seizure. We are all afforded protections under the Tennessee and U.S. Constitution from unreasonable seizures. That is the whole basis of criminal law. No unreasonable seizures. I think we addressed that in our question. Second, to go back to some of these cases, questions that the Tennessee Supreme Court have upheld as being a valid certified question do not contain specific instances of the Fourth Amendment or Article 7 or the other instances that you mentioned, such as State v. Heathcote, which is a recent 2020 case. The court accepted 3 certified questions in that one. Number 2 of which, whether the trial court properly determined information as to the credibility and veracity of the CI in the affidavit in support of the search warrant. There is no Fourth Amendment spoken of there. There is no Article 7. There is no case law. It just says, in very simple terms to make it easy as a title, this is the question. Did the court do it right? And I believe that's what we've asked of this panel. Did the court do it right? Was it a reasonable seizure or was it not a reasonable seizure? I understand Your Honor's point. The counter to that would be, if the certified question must be that level of detail, I believe it would be an entire brief. I believe you would have to quote all the law, any authority that you wanted to. The point of these is to present it in a way that labels the scope and limits and sets you up to talk about those limits in the brief. I believe that's what the purpose of Rule 37 is, behind the fact of allowing a little bit of a judicial economy. Judge, the only way to avoid a jury trial in this instance case was an agreement by both parties and the court to do a Rule 37. Rather than bring out 60 to 70 people and make them miss work in Polk County to have a trial just to get an appeal process, we opted to do the Rule 37 requirements. We followed State v. Preston. We followed other Tennessee Supreme Court precedents that don't require Article 4 or the Constitution written in them because it's written plainly. We believe our question was written plainly. If that satisfies your question, or if you would like to ask me anything else, Your Honor. Thank you, Judge. To the merits of the case, Your Honors, I pride myself as an American. I pride myself as being Tennessee born and raised from McMinn and Monroe County. Everything that we're taught in law school, everything that we're taught growing up, everything that we tell our clients when we practice law is the government can't just get you for any reason. They can't just stop you. They have to have some facts. They have to have that reasonable suspicion or probable cause or something, because all warrantless seizures are presumed unreasonable. Judge, the facts of this case which are set out throughout the record, set out not only in Judge Donaghy's order denying the motion to suppress, but also in the transcripts, were that an on-duty patrol officer in Polk County, Tennessee, received a call from dispatch and said, "Hey, there's a speeding driver." If you'll look at Judge Donaghy's ruling on the motion to dismiss, she further stated that, yes, the call was just about speeding. There was no time frame established by the state of Tennessee at the trial level. We don't know how long in time after that anonymous call came in until when the officer first saw the vehicle. We do know from testimony from the officer that he saw no illegal activity, he saw no speeding, he saw no traffic violations. In fact, he couldn't even get right behind him because when he did a U-turn, there was cars in between him, so he couldn't even read the tags at the time.
So may I ask just a couple of questions?
Sure, Honor.
Because I've read parts of it and then I may have missed part of it too. Okay. So by the time the officer got to where your client was, he was already in a parking lot? Or
How it happened was,
No, I mean, by the time the officer got to where your client was he in the parking lot?
he was about to turn into the parking lot.
About to turn into the parking
The officer testified that he saw him, I think, stopped at a red light. He did a U-turn, got behind him at several car lengths. There were some cars in between. He couldn't run the plates.
Be that as it may, your client pulled into a
Pulled into a parking lot immediately after that, into a space that
So he
abuts
was in
up to the wall.
space, and then the officer pulled beside him,
No,
behind him?
directly behind him, Your Honor. You can see it in the picture.
Now, he didn't turn on his blue lights at that time.
He did not, Your Honor, not at that time.
And your client got out of the car? His car?
Your Honor, according to testimony from the officer, he could not recall whether or not the defendant had already exited the vehicle or was maybe opening the door when the officer engaged
But
in the
Perhaps
conversation.
in the process of getting out.
Perhaps in the process of it, we don't know, Your
Okay,
Honor.
so did the officer get out of his vehicle at that point in time?
Yes, Your Honor. The facts were,
I thought there was something about talking through a window, but maybe I misunderstood that. Did the officer talk to your client through his window of his vehicle?
Judge, that's not my recollection of the facts.
Okay.
My recollection was that the officer got out of the vehicle after parking behind Mr. Burrell's vehicle. That was, at that point, the only way out would be to walk away.
Your client got out of his vehicle?
Yes, after the conversation had engaged.
So he talked to your client through his car window? I'm just trying to figure out where I couldn't quite, it was not clear, and so that's why I'm trying to understand.
Just my recollection of the facts was, if Mr. Burrell was parked, the officer parked behind him,
Right?
got out of the vehicle and began a conversation.
While your client was still in his car or after he got out of his car?
I believe he got out of the car while Mr. Burrell was still in, and Mr. Burrell began to exit as the officer walked up. As they began the conversation,
Not because the officer told him to get out, it was just he was getting out.
there was no direction to leave the vehicle.
Okay, so he got out, and
He got out.
then they had the conversation. So your client did not get out of his vehicle because the officer told him to get out?
That was not in the facts, Your
It's
Honor.
not in the record as far as you know?
Yes, sir. That's correct.
Okay. All right, thanks.
Thank you.
kinda
If that
gives me-
answers your question, or if I could
All right, yeah.
help expand upon
Sorry,
that.
I'm just, in my mind, I was trying to get it straight. I knew there was something through the window, and I was trying to, and your client was in the process of getting out of the vehicle.
And I'm not sure if the window was down and maybe he tried to speak to him. I don't know that there was actual any communication through the window or not, Judge.
Sure. Okay, thanks.
You know, the notes that I have, and again, these are from the briefs, who haven't read the record, are basically the officer pulled up perpendicular to the truck and asked if everything was all right. So and before that, it looks like the driver was either out or getting out of his truck. And somebody then said, the driver basically said he had been drinking. And then the officer backed his patrol car up, got out, and continued to investigate. Now, whether that's what the record shows or not, that's probably from my notes from the briefs.
My recollection of the record and the motion to suppress, Your Honor, was that there was no mention of drinking until after the officer had gotten out of the car and some actual formal questions had then started.
So in this situation, what are you saying is, you know, if a person is out in a public place, okay, and an officer is also out in a public place, and the officer goes up and starts talking to a person, you don't consider that to be a seizure?
I would not, Judge.
Okay. So how is what you're saying the facts are in your case different from that? In other words, you have an officer getting out of his vehicle, going up to your client who's getting out of his vehicle, and they have a conversation. So what's
The difference would be, Your Honor, that the vehicle was blocked in, one by a wall in the
But
front.
he wasn't getting ready to drive anywhere. He was getting out of his
We don't
vehicle.
know, Judge.
He could walk away, couldn't
He
he?
could walk away, but Judge, I don't think it would be reasonable to ask someone to leave their vehicle to walk away to not escape, but to avoid an interaction with authorities. I believe you're right. There is no law saying you could not walk away because he was not formally arrested at that point, but the trial court did find that a seizure had occurred at the time that the cop car or officer's car was pulled behind Mr. Burrell's vehicle. The trial court's determination was, even though a seizure had occurred, it was reasonable that he did park it there because of a 911 call of speeding. And so that's kind of the point we're trying to make, judges.
I understand about the seizure. The other question, though, was you said that the officer then got back into his vehicle, I assume left the defendant standing there, and moved it?
It was blocked in originally. I believe the reason for the moving of the vehicle was to better position the camera, the dash cam that was on front of the car, because you could not see the entire interaction. I do not recall ever being given a body camera. All we had was the dash camera that had audio.
Was there any discussion about a driver's license at any of that initial contact?
Not to my recollection, Your Honor.
He didn't ask for the guy's driver's license or anything?
Not that I
While they were standing there? when the
Not that I
person-
recall, Your Honor, no. And I don't believe those questions were asked at the motion to suppress either, Your Honor.
Okay, all right, thanks.
One thing I would like to point out was for the independent anonymous caller, the judge did rule that it was only for speeding. That's what was that's what was given over to the officer to be on the lookout for a red Chevrolet truck that was speeding. And so when he did, we don't know how long later, when he did see a red truck, he tried to get behind the truck and verified he is not speeding, he is not breaking any law, and he is not committing any traffic violations. But even though that was the case, and even though he had no independent corroboration of speeding or any violations, he still chose to park the car behind Mr. Burrell. I think this further answers Your Honor's question, Honor Montgomery. All he had to do was park beside him. He could have talked to him all day long. He could have walked with him in the store, could do whatever he wanted, but he parked behind him. And so I think that's where we're trying to draw the line, and that's just unacceptable, because we should not be seized based on an unknown caller's 911 call of past speeding. Because what kind of Pandora's box does that open? We already have pretextual stops that are allowed. We have good faith exceptions. If this is to stand, then a seizure can occur just based on an anonymous call of speeding. So that's kind of why we're here, Your Honor. Thank you.
Thank you. All right, General?
Good afternoon, Your Honors. Abigail Renard for the state. As everyone this afternoon, I would also like to extend my condolences about Judge Witt's passing. It was an honor to practice before him, and he'll be missed.
Thank you.
Turning to this case, this court should dismiss this appeal. The defendant's certified question of law is overbroad, and it fails to clearly identify the scope and limits of the legal issue. But if this court does address the merits, it should affirm the denial of the defendant's motion to suppress. Even if the officer did immediately seize the defendant, the seizure was supported by reasonable suspicion. So first, addressing the defendant's certified question. The defendant's question is overbroad and doesn't clearly identify the scope and limits of the legal issue. As Judge Wilson pointed out, the defendant doesn't reference the specific legal principles that he's relying on. Admittedly, he does kind of talk about, this unreasonable seizure, and kind of, you can infer the legal principles he's relying on, but that's the problem, is that Preston and Rule 37 require more than that. It requires the question to be specific and to identify more specifically what his reasons are, what he's relying on, and just define that more clearly. And I think even more of a problem than that is that it doesn't identify the evidence that he is seeking to suppress or even mention suppression. It is, again, this can be inferred from the context that we're here because a trial court denied his motion to suppress and he's seeking suppression of some evidence, but it's not clear what that evidence is. It's not clear what the trial court did based on the question. And there's just a lot that has to be inferred from this. And the trial courts, again, the reasons for denying aren't clear. You know, was it because the court found that there was reasonable suspicion? Was it because the court made a factual finding that the caller wasn't anonymous? That there are any number of reasons, and it is not clear from this question why the trial court denied the motion to suppress.
Let me just say, and I probably shouldn't say this, but I don't think in 16 years as a trial judge I ever properly certified a question because I didn't know how, when the lawyer brought it to me, whether it was good or not. Why this statute that is designed to create a quick way to get to the appellate courts has been interpreted to be such a minefield that's almost impossible to get through, I don't know. It is, I've tried to hint that it needs to be looked at by the legislature or someone, but it is, I've never seen a certified question where the state's brief didn't begin with this question is not proper. And most of the time they're right. And it's just, I think most trial judges have the same feeling. I did that for 16 years. And as appellate judge, I'll just shake my head sometimes when I try to figure these out. Anyway, that's my soapbox.
I can understand the difficulties of interpreting Rule 37, but nonetheless, it has been interpreted to require that type of strict compliance. And the defendant here has not strictly complied with Rule 37, and this appeal should be dismissed. But even alternatively, if this court did address the merits, this court should affirm the denial of the motion to suppress. And to start, I would like to briefly just clarify some factual issues. So the way this came about is there was the 911 call that came in about a red Chevy truck that was speeding. I believe the 911 caller talked about him flying down the road or something of that nature, and identified the area, provided the license plate number, and the officer was dispatched to the area. He arrived in the general area where the call had originated, and is driving down the road and sees a red Chevy truck driving the opposite direction past him. So the officer continues driving, makes a U-turn, gets, I believe, one car behind the truck, and then is following the truck, trying to catch up to it. In the meantime, the truck pulls into a Family Dollar parking lot, parks in a spot right up against the Family Dollar store, so right in front of the store, and the officer follows him in, pulls up behind, and stops perpendicular. It's not clear whether the officer has parked or is just stopping with his foot on the gas. He's just kind of pulled up behind the defendant's truck. Meanwhile, the defendant is either in the process of getting out of his truck or is already out of his truck. It's not clear. The officer doesn't quite remember whether he had actually fully gotten out of the truck or not. And the officer rolls down his passenger side window. To your point, Judge Montgomery, this is the through the window part. The officer asks through the window, "Hey, is everything all right?" And the defendant comes up to the truck, or up to the patrol car, and begins talking to the officer. And at that point, the officer smells alcohol, notices that the defendant's speech is slurred, and I don't recall at that point if the defendant admits to having had some alcohol. I believe he does. It might be later in the interaction, but he certainly admits to speeding. And then the officer backs up his patrol car, puts it in park, gets out of the car, and goes to further investigate a potential DUI and interact with the defendant.
So is it the state's position that at that point, when he again backed it up, is when the seizure occurred?
Correct. That is the state's position, is that that's when the seizure occurs, not when the officer first rolls up behind the defendant. The officer acknowledges in his testimony, as does the state now, that the defendant's truck was blocked in. The defendant could not have driven away without hitting the curb, the store, or the patrol car. So from the beginning, his truck is blocked in, but under the totality of the circumstances here, a reasonable person would have still felt free to leave, which is the relevant test for a seizure. So sure, the fact that his truck is blocked in is a relevant consideration, but it's not determinative here. The officer is, the trial court described the interaction as cordial and friendly and conversational. He's talking to the defendant through his passenger side window, not even right out of the driver's side window. He doesn't display any weapons. He never turns on his blue lights. He's not taking any sort of threatening action or even saying, hey, I want to talk to you, or being any type of aggressive. He literally just says, hey, is everything all right? And so under a reasonable, under the totality of the circumstances here, this was not a seizure at that point. It's later when the officer backs up to better block in the defendant. And at that point, you can see the rest of the interaction on the dash camera video. The beginning part, you can't see it, but you can hear the officer's tone, and you can hear their conversation and hear what's going on. And the defendant's speech is very clearly slurred. But then, even if this was a seizure, it was supported by reasonable suspicion that the defendant posed a threat to public safety by driving recklessly. The 911 caller identified this red truck that flew by his car. He expressed that he tried to catch up to the defendant and slowed down once he hit 80 miles per hour. And he gave a description of the truck, including the plate number. And these specific facts gave the 911 dispatcher the ability to form a reasonable suspicion about the defendant's behavior. And although the call was anonymous, the details of the report, combined with the officer's verification of those details, established the reliability of the 911 call. So first, the use of the 911 system adds some amount of reliability to the phone call anyway. And then the caller relayed his personal observations and the actions that he took in response, such as speeding up, trying to catch the defendant. And that suggests that he was reporting it as it occurred, which establishes his basis of knowledge. Then,
So let me just ask you this. If I'm riding home today with Judge Wilson back to Middle Tennessee on the interstate, and he passes someone at 80, the officer has probable cause to stop him.
I don't know that it would rise to the level of probable cause, and I think it would depend on...
Reasonable suspicion then.
Yeah, I think it would depend on what road it's on. I think, in this case, the judge, they did identify the area. They didn't talk about the speed limit, but it seemed fairly clear from what the area was that driving 80 miles per hour would have been reckless on that specific road. So, I think it depends on the context, and in this context, I think it did rise to that level. But 80 miles per hour on a highway where the speed limit is 70.
But the evidence, the facts show something about the road.
The facts show I think the facts are what the road was, that it was, I don't recall what the name of the road was, but the officer does name the road, does name the area, and the area, the defendant is in the same area when he pulls into the Family Dollar. So it appears to not be on a highway where the speed limit is 70 miles per hour. But I think even if it were on a highway where the speed limit was 70 miles per hour, he's still speeding, and that is certainly sufficient for the officer to pull him over and stop him, which the officer here did not even do. He pulled into the Family Dollar of his own accord. The officer didn't pull him over, but I think if this were a situation where the officer had pulled him over, I do think he would have had reasonable suspicion to do so based on speeding. But again, the trial court did make a specific factual finding that it would have been reckless driving in this case on that road. And then to go back to the reliability of the 911 call, the officer was in the area where the report originated. He saw the truck that matched the description. It had the same tag number, and this all established the caller's basis of knowledge and credibility. And so the 911 tip was reliable and gave the officer a reasonable suspicion. And if this court has no further questions, we ask that you either dismiss the appeal or affirm the denial of the motion to suppress. Thank you.
All right, Mr. Hayes.
Your Honors, briefly, I want to address the Florida v. JL case that the United States Supreme Court decided in 2001, I believe. I believe I referenced it in my brief at length. Your Honor, those facts are not identical, but very on point. It was an anonymous caller that said a young black African-American man had a gun. The officer showed up. He didn't say anything. The court ruled in that instance that a seizure was not appropriate because there was no independent corroboration. Your Honor, the state did not even bring the 911 caller or the dispatcher to the motion to suppress. They had no corroboration at any level. The officer did not, the court did not. They are just assuming that an anonymous caller is telling the truth about a car maybe or maybe not going 80 miles an hour. We don't know, did he have a radar? We don't know, did he have were any of his gauges on his car properly function? We don't know any of that. That wasn't our burden to bring him. That was the state's to help to try to tie together the corroboration there. Judge JL, the United States Supreme Court case JL, specifically says identification is not enough. Just because an independent caller identifies someone like they did in the JL case does not mean that there's enough to have a seizure. That can help corroborate, but it's not enough to get over that threshold. It doesn't give you reasonable suspicion.
So you told us on your initial argument that you agree he at least could have walked away. So tell me exactly when you say the seizure occurred.
The trial court ruled that the seizure occurred at the time that the officer blocked him in. I believe that is what we are limited to on this appeal, because under the certified question of law, your honors can only determine what is here. We did not ask for a determination on whether a seizure occurred, only on whether an unreasonable seizure occurred, because the trial court already ruled that a seizure did occur at the time that he was blocked in. That's specific in her ruling. Does that answer your question, Your Honor?
You did.
I have the follow up just a second. So maybe the record will clear this up. The way I'm sort of envisioning what happened, the officer pulls in behind him with his window down, and the defendant gets out, and he says, "Is everything all right?" Something occurs, and then the officer backs up further and blocks him in, if he wasn't blocked in, and then gets out of his vehicle. Is that right or wrong?
Judge, my understanding of it was if there was any statements through the window, it was not on the camera, and it was very brief, and it was almost immediate that the officer exited the vehicle and approached Mr. Burrell. I'm unaware of Mr. Burrell approaching the vehicle. If that happened,
Just talking to him, and it's approaching, getting out of his vehicle and talking to the officer through the window, and then later talking to him again. Okay, we'll just read the record and see what it says.
Understood,
I'm just
Your Honor.
having a hard time figuring exactly how it occurred.
understood, Your Honor. I don't want to misrepresent any of the facts, but my understanding of it was it was all pretty immediate how it happened. It wasn't like an elongated process or anything. I believe I'm out of time. Thank you.
All
very
right,
much.
thank you, counsel. Thank you, counsel. Appreciate your arguments. We'll take this under advisement, get you an opinion out as soon as we can. And with that, we are adjourned.
All right.